That's on. What's going on, ChavezzSlovakia? I didn't know you guys were here, but it's good to see you. And I hope you guys are doing well. You see, I'm just hanging out. So we're doing the legal video. I suppose it's a good time now as any, but to do it. So let's get into it. That's what I planned on doing. This is the SpongeBob SquarePants crab versus plankton legal battle. So there was an episode of SpongeBob SquarePants where Plankton was trying to get the Krabby Patty recipe, and he goes into the Krabby Patty. He pretends to fall on water, I think. There was no sign about it in the establishment, right? And then he sues Mr. Krabs over it in attempt to get the recipe. So let's see what he has to say about it. Let's get into it. Play. That tie is legit.
Squarepants technically qualifies.
I surrender!
Be sure to comment in the form of an objection, which I'll either sustain or overrule, and stick around until the end of the video where I give SpongeBob SquarePants a grade for legal realism. So, without further ado, let's dig into this episode of SpongeBob SquarePants Crabs versus Plankton.
Okay, I wanna object to something.
Okay, so Plankton is going to the Krusty Krab in order to steal the recipe for the Krusty Burger. Wait, no, that's The Simpsons.
Go!
He's going to steal the recipe for the Krabby Patty. Okay, that's it. The Krabby Patty, which is probably some sort of trade secret in the same way that Kentucky Fried Chicken is a trade secret or Coca-Cola is a trade secret. But I'm guessing Plankton probably does this on more than one occasion, kind of like Wile E. Coyote.
That was easy. Maybe today is the day I'm gonna steal the Krabby Patty formula.
Bow. So
All
it's
right,
a legit
classic
fall.
slip and fall case. There is an entire genre of lawsuits devoted to exactly this kind of thing, this kind of personal injury, because it's so easy to fake your injuries like this. So this is the kind of thing that gives lawyers and lawsuits a bad name.
Look at you, Plankton. Once again, you're falling flat on your back in another pathetic attempt to steal me formula. Though you tried, you haven't had the smallest nibble of my delicious formula.
So like following along here, I don't know if he's seen much of SpongeBob SquarePants from this. I can't really tell. But legally, I mean, I know that you have to have signs present. You know, when you go to slip and fall on something, I know that how you act towards the person matters. If you're taking responsibility for it or not, or you feel like you're responsible or not, matters. I know if you're the owner, like Mr. Krabs, it really matters like what you do during the conversation with him. But that's really about it, man. I got nothing else for you.
And you never will.
I mean, the guy has already injured himself. There's no reason to be mean to him and taunt him when he's on the ground. Not a good idea for a restaurant owner to be malicious.
That's what I think.
Sleep at night knowing you're a complete failure.
There really should be a wet floor sign.
Ooh.
Yeah, if that were me who slipped, I'd sue old man Krabs for all he's got.
You know, that's a very good point. There probably should be a wet floor sign in the vicinity when someone is mopping up the floor. Although, query how you can mop up a floor and have standing water when you're literally underwater in the first place.
Super water is the answer to that. It is clearly the superior H2O. Maybe it's oil, so it doesn't mix, so they think it's water, but it's really just oil.
Putting that aside for the moment, I think these patrons are absolutely right that there should be a wet floor sign in the vicinity.
Does that include the Krabby Patty formula?
Of course.
He said, of course.
Oh, the pain! I can't feel my arms and legs. I think they're broken.
Look at him shriveling.
Plankton have arms and legs?
My
No,
pain and suffering.
they don't. That's why it's great.
Oh, that looks bad.
Uh-oh.
Poor little man.
Now pity's on his side. It's over.
Hold up a second. Plankton, we don't need to drag this little incident into court, do we?
Well, if you transfer the Krabby Patty formula to me, I'll forget your gross negligence.
Is that legal? Can you do that? I've always wanted to know. I've always wanted to know if something happens and I get hurt, is it legal to negotiate out of suing? Is that a legal thing to do, or is it like if you don't do this, then I sue, and that's okay?
Scoundrel! You'll have my formula when you pry it from me lifeless claws!
Yeah, so this is actually based off of the real-life case of Whelan versus Van Natta, where someone went to a shop legally, but then snuck around in a private residence that was attached to the shop. The issue at hand is the question of being an invitee versus a trespasser. An invitee is someone that is there for regular business purposes, and a trespasser is someone who does not have permission to be on the property.
So an invitee has different rights then, I'm assuming, of somebody that rather than being a trespasser. That makes sense.
And generally speaking, landowner must act as a reasonable person would toward invitees. And to figure out what a reasonable person would do, you look towards others who are in exactly the same place. Given that we see wet floor signs just about everywhere, you can bet a reasonable restaurant owner would probably put one out if they were mopping the floor.
Right.
Or they probably wouldn't leave standing water in your restaurant in the first place where people can trip and fall.
That
now,
makes
with
sense.
respect to trespassers, though, a restaurant owner or a landowner doesn't owe the same duty of care. Basically, if someone is trespassing on your property, your only obligation is to not hide dangerous things or create dangerous situations.
So like a moat is okay because it's not hidden, right? If there's a sign that says, "Here lies moat, matey," it's okay then. But hidden bear traps, not okay. I think I'm following this.
On the premises, like a guy who created a shotgun booby trap to punish people who were breaking into his house.
Don't do that. Why are you laughing at this?
You know, what's really interesting about this particular case is that California did away with that invitee trespasser distinction and replaced it with a sort of general reasonable person standard. In the case of Rowland versus Christian, the invitee trespasser distinction was found to be unhelpful by the court, and the court just held that the landowner owes a duty to act as a reasonable man, now a reasonable person, in sort of general. So it doesn't really matter what the status of the person who is injured on the property is.
Oh, that's
you
terrible.
You always have to act as a reasonable person.
That's so weird. Isn't that weird that it doesn't matter if I want you here or not? I can still be held liable just for the state of my things. Doesn't that seem really weird? That seems weird to me, like a personal affront to my space. You know what I mean? Like why do I have to make allowances for people that I didn't invite on my own property? You know, if I'm fixing something in my own home, is it then separate because I'm on a personal residence rather than a place of business?
Krabs has not put out the sign that says there's a wet floor, and so he's probably liable under the California standard.
Oh, so I'm looking at it from the wrong direction. Reasonable as in reasonable for other people in your, so like if I own a store, I should do things that people in stores normally do. And if I own a home, I do things that people in homes normally do. So and people in homes don't normally put up signs that there's a hole there, which you don't, then I'm not held liable for that. But in a store, people do normally put up wet floor signs, so you are held liable for that. Okay, you are responsible for those things. Got it. Makes sense to me.
See you in court, Krabs! I mean, oh, the pain! The deep frying pain!
The deep
now, of course,
frying
Plankton
pain.
is malingering here, and he's faking all of his injuries, so that sort of shows you that he hasn't actually suffered any damages here in this particular case.
Got it.
He's really perpetrating a fraud on both Krabs and the court. But sometimes you can have a court case where you're entitled to $1 in damages, because I think Krabs may have been in the wrong to not have a sign out with respect to everybody else. And so Plankton fell. He just didn't really have much damage as a result of that. So he might be entitled to what are called nominal damages, and a jury might end up awarding him $1 instead of the millions in the recipe that he's
nominal
seeking.
So if you want to be real petty, you seek nominal damages, and you could be as petty as you want and just be having people in court, which probably is a bad idea, but still, you could.
I'm in a blue ruin. I'm doomed.
Don't worry, Mr. Krabs. I will do whatever it takes to keep the Krusty Krab formula from getting into Plankton's evil hands.
What I really need is a good lawyer.
Whoa, did somebody say lawyer? Richard A. Bottom Feeder, attorney at law.
I take exception to that. Lawyers are not bottom feeders, even when they are literal bottom feeding fish.
I couldn't help but notice that despicable display.
So, how much is this gonna cost me?
Actually, I won't charge a dime unless we win.
'Cause I really need is a good lawyer.
Whoa, did somebody say lawyer? Richard A. Bottom Feeder, attorney at law. I take exception to that. Lawyers are not bottom feeders, even when they are literal bottom feeding fish. I couldn't help but notice that despicable display.
Mm.
Actually, I won't charge a dime unless we win.
Yeah, that's a pretty standard thing for a plaintiff's attorney to charge, and especially in a personal injury lawsuit because of the risk. And generally speaking, if you're a plaintiff in a personal injury case, you probably don't have the fees to pay someone hundreds of dollars an hour to represent you. So a plaintiff's lawyer in this particular situation would probably ask for somewhere in the neighborhood of 35 to 50% of any recovery. While it sounds like a lot, the lawyer is actually in a precarious position where, number one, the lawyer might not recover anything. And number two, the lawyer has to front a lot of the court fees and court costs that go along with the lawsuit, which can add up pretty quickly.
Right. See, that is one thing also that I wonder sometimes about those kind of fees, you know, where people complain about like the prices of the lawyer. But when you pay the lawyer, it's my understanding that you don't pay for anything else. You pay the lawyer and then they worry about it. I thought that you were on more of responsibility if you don't have to front them any money. I thought that meant they come to you to file the paperwork and charge you. I didn't understand that the lawyer also in some cases takes care of that cost. That is actually really generous to me.
Generally, what people do is they file what are called compulsory counterclaims. So they are things that arise from the same set of facts. And here, Krabs doesn't really have any compulsory counterclaims. There's nothing that must be brought at the same time that results from the same nexus of facts that the lawsuit arises from. The opposite of that is a permissive counterclaim, which you can bring in the same action or you can bring it whenever you want because it doesn't really relate to the claim at hand. And that's what this lawyer is asking to bring in, is whatever past deeds have happened.
Run along, make things shipshape for my victory celebration. I've got to get to the courthouse early. There's only a few free parking places.
Oh, this is gonna be a slam dunk.
Oh my God.
Mr. Krabs' lawyer, speak to me.
Oh,
With pain.
oh
so
no.
Sometimes this does actually happen. Sometimes the lead trial counsel is rendered incapacitated and you have to pick up with somebody else. In fact, when I interviewed my friend Brent Wisner, who was the lead trial counsel in the Monsanto Roundup cases.
Really? He did that? Did y'all? Yo, we about to do that. Y'all might not have nerded out like I nerded out, but I'm finna do that. Let's continue. We're gonna power through this now because I need to see that. I'm so sorry.
To handle
I'm out.
Was injured in a windsurfing accident.
That's so cool. Yeah, that case is real deal Holyfield, y'all.
I'll give you one last chance. I'll drop the charges if you give me the formula.
Never, you little whelp!
Ow, ow, my little arm!
No,
my little arm!
On him.
Ow, my other arm! Ow.
He's lying!
I will say this is a little ridiculous. It doesn't make any sense that Plankton would actually fight Krabs. I don't think Plankton actually even have arms, and I don't even think Krabs and Plankton interact with each other in the ocean anyway.
Yeah, I was about to say, Plankton and Crab do interact. They eat them little mugs, bro. Crabs are bottom feeders, fam, bro. I think most people play.
The rest of
Where he could be.
We're back.
Thank you for joining us, Mr.
Spongebob lawyer pants, Your Honor.
No, no.
Yeah, that is the unauthorized practice of law. You are not allowed to represent other people if you have not gone to law school and passed the bar.
I am loving how serious he's taking this because I don't take anything serious, so I'm loving it.
SpongeBob would face serious repercussions from pretending to be a lawyer right now.
What are you doing here, SpongeBob?
Trying to get everybody to go to jail. Let's all go to jail.
Don't worry, Mr. Krabs. I have everything under control. It's all in here.
Really?
Yep.
You gotta say so. No, don't do
Is
it.
there a problem?
This man does not look like he's ever seen SpongeBob, and I'm loving this part of it because that is what makes this really good. Ow!
Ow, ow.
Although it's very sympathetic, I really would not counsel Plankton to represent himself here. He would do much better to have an actual lawyer to represent him instead of doing everything on his own. That doesn't tend to end well for people.
I wasn't always the tortured shell of a protozoa that writhes in pain before you today.
That's so good. That's so well written.
Was a vibrant, carefree, happy-go-lucky single
I'm sure you were.
Pull yourself together, boy.
Then came the fateful day that I paid an innocent visit to the death trap known as the Krusty Krab.
It doesn't actually matter if Krabs intentionally put the water there or not. Certainly, if he did intentionally put the water and tried to hurt some people, then that would be far more than actual negligence, and that would border on an intentional tort. But just the fact that he was careless and did not do what a normal restaurant owner would do would be enough to be guilty, or in this case liable, for negligence.
Well, you're kind.
They're all like crying and shit.
Suckers.
Does the defense have an opening statement?
Yes, Your Honor. Poor Graham!
I probably don't need to tell you that that is a...
This item.
It's a wet floor sign.
Do
That's
you
cold.
own one?
Well, no, I don't.
Wow.
I gotta hand it to Plankton.
Yeah.
That's a great question to ask
he nailed him.
cross-examination. Assuming that Plankton knows that Krabs does not, in fact, own one of these signs, that is probative to the case at hand. It helps demonstrate his
That's good.
negligence.
That's solid.
By the fact that he doesn't own this sign, he couldn't put it out, and the sign potentially would have prevented his injury in this particular case. Good cross-examination. Well done.
And it's funny.
But I also don't think Krabs' defense that he doesn't have the money for the sign would hold any water. Here, if you're not financially able to have a sign that is sort of necessary for all restaurants and stores to have, odds are you probably shouldn't be in business.
I took out $1 and dropped it in the blender.
Obliterate.
Oh boy.
Daddy's got you. Daddy's got you.
Obliterate.
Daddy's here.
Yeah, so in addition to showing that SpongeBob did no preparation in terms of preparing his witness and defendant for actually taking the stand here, he's also asking questions that are in no way relevant to the case at hand. Whether or not Krabs is cheap in general does nothing to address the fact of whether he committed a negligent act in the first place, except to the extent that Plankton has already done to show that Krabs didn't own a sign.
Defense calls Plankton to the stand.
Okay.
Why did you go into the Krusty Krab that day?
Yeah.
That's a really good question.
Yeah.
That would definitely help his case if Plankton actually answers truthfully here.
Steal the formula of the most delicious, sweet-smelling sandwich known to Bikini Bottom?
Huh?
Krabby Patty.
I can't take it! Gimme! Yippee!
Well, he didn't really answer the question, but he did show that he was faking all of his injuries, which probably is not going to be good for his particular case. But interestingly, as we established, putting aside the fact that Plankton totally faked all of his injuries, it depends on the jurisdiction. If they were in California, I think arguably Krabs was probably in the wrong. If we're in most states, however, Plankton was in the wrong because he was a trespasser and not an invitee.
Has the jury reached a verdict?
We have, Your Honor. We find the defendant not guilty. But he is cheap.
So this is a civil case. Civil cases don't decide guilt or innocence.
Okay.
Civil cases decide damages and who's liable and who's not liable. So the jury would not decide that Krabs was not guilty. They would decide that he was not liable.
It's a wet floor sign. I made it myself.
Well, it'll do.
It's better than nothing, I guess.
Okay. So we'll get just an overview of the grade. But yeah, thank you guys for rolling through for this. It was a lot of fun. I'm glad I got this from the Tier Zoo. There'll be some parts cut down from this video, so make sure you go check that out. I'll see y'all later, man. Peace.